Hello, everyone, and welcome to today's webinar presentation, How to Maintain Immigration Compliance. Today's discussion will be focused on maintaining immigration compliance through a combination of training and comprehensive policy, understanding the I-9 form, and when to utilize E-Verify. Before we get into the content today, I would like to take a moment to introduce myself. I am Stephanie Zielinski, and I'm the Marketing Director of ComplianceHR. You may recognize my name from this webinar's invitation, as I'm the one that you would have emailed with questions about the presentation, which I always encourage. And on that note, today's presentation will be recorded and emailed to you once it's available online. I would like to thank all of you for joining us today. We acknowledge that it's not always easy to take an hour out of your day during the busy end of year and holiday season, so we greatly appreciate you being here. Before I introduce the solutions that may best support you, I would like to introduce ComplianceHR. For anyone unfamiliar, ComplianceHR is a combination of two incredible and innovative organizations. Powered by the AI technology company Neotologic and the subject matter expertise of Littler, ComplianceHR delivers expert employment law guidance in a fraction of the time it could take otherwise. Our goal is to simplify the complexity of employment law, something that we will learn a lot about during this presentation. If you frequent the ComplianceHR and Littler joint webinars, you know immigration is not a topic that we often cover, as we don't have one specific solution related to immigration alone. However, we are always working to keep our clients and our audience informed of all compliance, even if it's not directly related to our solutions. So for those of you who are not yet clients, ComplianceHR has a variety of products designed with expert content from Littler to assist you in complying with an employee handbook policy, wage and hour, paid leave, COVID, and other labor law requirements, some of which include, of course, immigration. Our objective is to help your compliance strategy become proactive instead of reactive. So today I would like to introduce to you our compliance essentials. PolicySmart is a comprehensive handbook solution that provides you with federal and state compliant templates, a compliance timeline, handbook checklists, and even automated emails to alert you on new legal changes going into effect in your jurisdiction. The Reference Center is a new solution that combines many of our other rapid reference tools, and this solution quickly provides you with information on a wide range of topics at a glance. A little bit on immigration and PolicySmart. Within our PolicySmart solution, we have something called state guides. State guides carefully track state and local specific distinctions from those general national policies. In the state materials, you'll find addenda that identify protected categories under EEO laws, and immigration is one of the topics that may be covered. So if your state has specific policies in addition to the national policies, we will have that information in our PolicySmart state guides. On the screen, you'll see an example of California's Commitment to Diversity Statement, which does mention how to treat immigrant workers in relation to this. This tool is a great way to search for local labor law nuances. All right, now you may be wondering, how do I get my hands on this solution? Well, we would like to offer you a custom demonstration, 2 weeks of complimentary access, and love to hear about your compliance strategy to make sure that we are supporting it in a way that's applicable to your organization. I'd like to immediately reassure you this is not a sales pitch. This is something where our team will sit down and walk with you to understand what you need and how we can help you get to be the most compliant using our tools. So on the screen, you'll see a link to our demonstration website. Please feel free to register for a complimentary demonstration. If you would like to watch the webinar, really understand deeper this topic, you can click the link in the links panel. And again, we will send an email after the fact. So we do welcome you just registering for a demonstration, sitting down and talking with us about your compliance strategy. Now I would like to introduce you to today's presenter, Mr. Bruce Buchanan. Bruce counsels employers on immigration compliance issues and on U.S. immigration and customs enforcement inspections and audits. So Bruce, please take it away.
Thank you very much. I appreciate it, Stephanie. So we're going to spend most of our time talking about what else, the I-9 form. So, and right away, don't want anybody to be all freaked out. The current one it says it's dated 10/21/19. It's available at that website. Um, but one thing that might freak you out is at the document itself says it expires on 10/31/2022, which is about a little over a month ago, but it is still in effect. So I've already had a few panic phone calls. Hey, we don't have the right I-9. Where do I get it? Well, you still got the right I-9. USCIS has not issued a new one. So as you should know, the I-9 is for use for new hires and for rehires, though you don't necessarily have to do it for rehires if you'd like to use Section 3 of the existing or the old I-9. That's an option, and it depends on, quite frankly, a lot of different factors as to whether it's better to get a new one for a rehire or use Section 3. Another, quite frankly, common misnomer is I've had people go, well, we don't really have to worry about the I-9 because all of our employees are citizens. This has nothing to do with citizenship. It has to do with work authorization, whether you're a U.S. citizen or permanent resident or authorized to work or a U.S. national, which are fairly rare, the U.S. national. Now, one of the reasons why they haven't put out a new I-9, even though it was technically expired a month ago, is for the last about year, the USCIS has been exploring making significant changes in the format of the I-9. Probably not really in the content of the I-9, but the format. So depending on whether you've been around in HR for a while, if you've been around before 2013, you may recall that for all that time that the I-9 was a one-page form. And in 2013, it was expanded to a two-page form, which, in my opinion, was one of the best things that the USCIS has done. And I don't necessarily always compliment the government agency, USCIS, or any government agency. I used to work for a federal government agency, so I probably know some of the flaws within that. So, but that was a great change in my opinion. Unfortunately, they're going to go backwards. They're going to go back to the one-page form. Not really sure who's leading this debate, but and why they really want to do it. One of the reasons they said they want to do it is because it's going to help them on storage. Well, hate to tell you, but the two-page I-9 form can actually be one page front and back, or you may be doing it electronically, and therefore you have no. And last I checked, nobody said there wasn't any more storage on the cloud. But anyway, for whatever it's worth, they're gonna. I would say sometimes in the next 3 months, they'll put out the new I-9. There will be a supplemental page for the translator preparer. We are very hopeful, we meaning immigration attorneys in general, that they will expand the acceptable documents. As you know, there is on the third page, there's a list of acceptable documents, list A, list B, list C. And I'm on a committee that has been working with the USCIS for a long time to try to show them that there are a lot more documents that actually are acceptable and should be listed there. We will see if our guidance, I'll say that, to the USCIS is going to be listened to. I'm hopeful, but I'm not. I won't be shocked if they don't listen to us. All right. So another thing to, just one of the basics, kind of starting with basics and move from there, is the retention of the Forms I-9. You always retain current employees' I-9 forms. That doesn't matter if they've been there for 5 years, 10 years, 15 years, 25. You retain their I-9, and pretty much everybody has to have an I-9 now. There were people that were grandfathered in November of 1986. If they'd been hired before then, they didn't have to have an I-9, but that even for a lawyer, I think I can do the math, and that's like 36 years ago. So you're not really seeing too many employees that are have been employed at one employer for 36 years. Really important on your former employees. You can't just say, "Oh, they're gone," so therefore we don't have to keep their I-9. But unfortunately, it's not the simplest test known to mankind. You need to have both the date of hire and the date of termination to determine how long you have to retain that I-9. So it's 3 years from the date of hire or 1 year from the date of termination, whichever is longer. So you'd have to look at both of those. So just a quick way of thinking about it: if you're a long-term employee, say you've been there for 5 years, then you're going to have to keep it for a year past termination. If you're a short-term employee, say you've been there for 3 months, then you're going to have to keep it for another 2 years and 9 months, because that would be that would go back and got 3 years from the date of hire. You can purge your I-9s of former employees as long as it's past this period of time that you legally must retain them. It can be a good idea to purge. That would be probably for another session. But before you purge, make sure you've got 2 sets of eyes on I-9s that you're purging, because I've represented clients, unfortunately, that have purged, get kind of accidentally purged when they shouldn't have been purging, and then ICE came and audited them, and then all of a sudden it came out, hey, we don't have the I-9s for the terminated employees. So ICE wasn't too happy about that, to put it mildly. A couple things I want to talk about on in-person or remote verifications. As most of you know, pre-COVID, all I-9 verifications had to be done in person, no ifs, ands, or buts. But COVID changed things, as it did for so many things. And one of them was the ability to do remote virtual verifications. That rule policy came about in March 19th, 2020, which is essentially like one day after the federal government was basically shutting down operations for a while, and realized that there was going to be a bunch of folks, that were working remotely, and so what are we going to do with those folks? So they did, at that point, if everybody was working remotely, and you were working remotely because of COVID, and I should have put that in the PowerPoint. So working remotely because of COVID, then you could do remote verification. And this policy has been extended. Originally, they brought it in for 2 months, and then it was extended another 2 months, another 2, because they always talked about, well, we're gonna have to go back to the old way. This can't be the way forever. But in the last year, they've been expanding by 6 months or more. At the end of October, they said this policy would remain in effect to July 31st, 2023. So I guess that would be about a 9-month extension. So in April of 2021, they made it a little easier to do remote virtual verifications, because not everybody had to work remotely. But if you were working remotely due to COVID, then that person could do a remote virtual verification, just if that particular person was doing it. Now, on the other hand, and so they're exempt from the physical inspection requirements. Now, if they come back on a regular, consistent, or predictable basis, then, or the flexibilities are ended, which right now would be July 1, 2023, then you do have to do the physical inspection of the I-9 documents. And again, that if that's an issue for you, I urge you to reach out to Counsel. If you don't have Counsel, to reach out to me, because there's some there's some important things that need to be done at that period of time. Now, will we get virtual remote verification post-COVID? Post right now, July 31, 2023. The answer, typical lawyer answer, maybe. The Department of Homeland Security, DHS, issued a proposed rule on August 18th, 2022, in which they proposed to authorize to certain authority to the Department of Homeland Security Secretary using what they refer to as optional alternative document examination procedures, meaning, in easy terms, remote virtual verification. Now, this is like a proposal to have a proposal. They didn't propose any specific criteria for this. Instead, they said, well, we want to hear what the general public has to say, and we're looking at it from one of three options. One would be a part of a pilot program. Well, what do you think we already have for the last, essentially 2 years? It's been a pilot program. So that's really not particularly attractive. The second one is what immigration attorneys want, that the Department of Homeland Security determines that the procedures have the equivalent level of security and that you can do remote virtual verification going forward, regardless of COVID or any other type of health scare. Now, there may be some pieces that are tied to it. One piece that might be tied to it, in order to be using this, you have to sign up for E-Verify. Now, again, it's a proposal to have a proposal, so they've had their comment period. I know I was on a committee that responded to it, made a number of suggestions and comments. We are now waiting for the Department of Homeland Security to actually then issue an actual proposed rulemaking, saying this is what we're proposing, and then it will be another comment period. When that will happen, great guess. Hopefully before the middle of 2023, and so that there could be a comment period, and it can come, whatever is agreed to will be out by the fourth quarter of 2023, which also means that they will probably be extending again beyond July 31, 2023, the current remote virtual rules. That's all speculation. Don't take it to the bank. But it's from someone who, like I say, I sit on committees that we meet with Department of Homeland Security, ICE, USCIS. So we feel like we have some idea of how it's going to go. All right, so let's get back to just the basics within I-9 compliance. Ultimately, all parts of the I-9 are the employer's responsibility. Now, you might say, well, wait a minute. The employee is the one who fills out Section 1, currently the first page of the I-9. So I can't be responsible for that. I'm not the employee. Well, that's, you're correct that the employee is the one that fills out Section 1, but you're not correct if you're thinking, well, I can't be responsible. You are responsible to make sure that that was properly completed, and if it wasn't, you should bring it to the attention of the employee involved, and say, hey, you didn't. Let's say you didn't check off a box. You didn't say whether you're a U.S. citizen or U.S. national or permanent resident or authorized to work. You've got to check off one of those. So you should be reviewing it for completeness. So one of the most important features, besides making sure that the employee actually completes what is requested, is that when it must be completed. So for Section 1, it must be completed on the first day of employment or beforehand. So if they start on a Monday, but you made them an offer on a Friday, and they accepted the offer and they started doing, filling out the paperwork, then you can go on and put down the date that they're going to start. Well, in section 1 you don't need to put that down, but that would be filled out. So you can get that done actually, beforehand. If you want to get section 2 done on that Friday, you can, or you can turn around and get it done, as we'll talk about in the next couple slides here. A couple things to point out. I've already talked about checking off the box, getting all the information. For whatever reason, I still can't quite figure out why, but the telephone number and the email address were added over 5 years ago, maybe as many as 9. And it's always been optional. But if you look at the material, if you look at the I-9, where they ask for that information, you will never find that it's optional. Instead, you have to go read the instructions. Well, the instructions right now are 15 pages. They're talking about putting them down to 7. Most people don't read the instructions. So, you go on and most employees will record their telephone number and email address. The reason they ask for it, or at least the reason they say they ask for it, is if they're doing E-Verify and they get a tentative non-confirmation, they want to be able to email the employee as well as the employer. Why they ask for their phone number, I'm not really sure, because I've never heard of anybody getting a call from concerning that. But and vital, the employee should sign and date their name. And let me just comment on one. Date your name sounds really simple. I will tell you, I will say 10% of employees put their birth date down as the date they sign. So, I was born whatever year, and they put down I'm December 6th, 1958. It seems like pretty dumb, but I see it. I just was looking at some I-9s earlier this week. There was a guy that wrote down his birthday, and they already asked for their birth date farther up there. So I don't know why somebody thinks they need to give it again. But anyway, they do. The prepare translator portion, there is a little box that says yes or no whether one was used. I would say 50% of the people do not check off a box at all. Quite frankly, ICE, if they're doing an audit, they don't care. So it's kind of a useless box. It's you want to have the employee do it correctly. So if they're not using a translator, just put no. If they are, then you need to have that information filled in. If they don't use one, you don't need to fill in all the information, because there was no translator preparer used. You can be a company representative or a company employee to fill out the translator preparer. It doesn't have to be another, family member or employee. It can be somebody with the company. Section 2, of course, this is for the employer. And this is where you request documentation from the employee that shows their identity and employment eligibility. And as you should know, you can have a list A document in which the document will show both identity and employment eligibility, such as a U.S. passport, a permanent resident card, an employment authorization card. Those would be the 3 classic list A documents. Or you need both list B and list C. List B is an identity document. List C is to show work authorization. So if they don't give you a list A, instead they give you B and C, then you record it there. You never record in all 3 lists, A, B, and C. You either record in list A, or you record in list B and C. And there is a little, I know this is kind of small on the screen, but you see a gray line that goes all the way down between A and B. Kind of think of that as the wall, and you're not allowed to go across over the wall. If you filled in something on A, you can't climb the wall and put something in B. There's also the word or above the little gray line. But a few years ago, when more people were talking about the wall, it was more interesting to talk about the wall within the I-9. The documents, you are not the employer representative does not have to be the the greatest document expert around. You don't have to get your black light out and look at the document. All it has to be is genuine, appear genuine. So you don't know if it's genuine or not. It appears that it is, and relate to the person presenting it. If those two are met, you should accept it. Now, most employer representatives, quite frankly, are not in a position to give any kind of great guidance as to whether the document is not genuine. You haven't studied permanent resident cards, green cards like I have. I can look at one and within, I don't know, 15 seconds, I will tell you, oh, the thing's fake and this is the reason it is. These are all these little mistakes that are made all over the card. The government realizes, I realize, you don't have that type of expertise, and you don't need to have it, because if you do take a green card and it ends up being fraudulent, but it was, you didn't know it was fraudulent. It had the guy's name on it. It had all the various data that is needed. Then you accept it. It had his picture on it. Then even if ICE comes in later, audits your I-9s, and comes back to you and says, oh, Jose Alvarez is not authorized to work unless he provides alternative documentation that you provide to ICE, then he can't remain employed. You have to give him a period of time to find that, what I refer to kiddingly as newer and better documentation. So often it is newer and better. It's still fraudulent. So, but if he gives you something that's real, then that's fantastic. Then that person can remain employed because he has given you proper work authorization. And it happens about, I'd say, 5 to 10% of the time when you get when you're in the process of going through an audit or notice of inspection, and you get what's called a notice of suspect documents. There's a few, not many, that will actually come back and say, yeah, I just recently got this work authorization card because I applied for asylum, and so I am legal to work, even though previously I gave you a fake green card. So anyway, so you really don't want to learn, to become an expert on documentation, at least in my opinion, because if you hold yourself out as an expert and then you take a fake card, more likely that ICE is going to go, oh, so you say you're an expert, you took a fake card, so we're going to say you knowingly employed this person that was undocumented, and we're going to fine you, as opposed to, oh, you didn't know it was, so we're not going to fine you, you just got to fire the guy. So you'd much rather just have to fire somebody and not have to fire them and pay the fine. In most situations, ever since I think 2007, you can't accept an expired document. If you've been in HR before that, you could take an expired driver's license, expired passport, expired green card, and it was okay. But back about 2000, may have been 2008, they stopped that. But there are some exceptions. One of them would be the conditional 2-year green card that expired on its face, but the employee gives you a receipt showing that they have applied to remove the conditions and get a full 10-year green card. If they can give you that, then that EAD, employment authorization document, is good. TPS, which is temporary protected status recipients, often receive an automatic 6-month extension on their EADs, so you need to be careful about that and explore that situation. And then you have many categories of EADs where they get a 540-day extension for timely renewing their EAD, and though often those are only might be tied to the exact employer. But one of the most common EADs is for folks with DACA, Deferred Action for Childhood Arrivals. And for whatever reason, you cannot accept a DACA card past its expiration date, even if they show you a receipt showing that they've applied for a new 2-year card. Sorry, they're just out of luck. You're not allowed to accept that. But normally, the normal rule is they give you expired document, you're not supposed to take it. But when they give you one, hopefully it'll go off in your head. Oh, I'm not supposed to take this, except, and then you think about the exceptions and see if they fit within one of those exceptions. So timing. It's really important that this be done right away. Section 2 must be completed within 3 business days of, it says hire, we should say first day of employment. That may be the same thing, but the correct language there is first day of employment. And what is 3 business days from the first day of employment? Well, if they started on Thursday and it's a restaurant and you're open 7 days a week, then Saturday and Sunday count as those business days. So they started on Thursday, then Friday would be day 1, Saturday would be day 2, Sunday would be day 3. And they should have their I-9, Section 2 of I-9 completed by Sunday. You might say, but hey, yes, the restaurant is open over the weekend, but HR doesn't work over the weekend. Sorry, they don't care. The government doesn't care. If you're open, that counts as a business day, so you need to get that done. If you do not get it done within 3 business days, and you do get audited, ICE will issue you a penalty, a fine, if they're issuing fines. If they decide not to give you a warning notice, they're going to give you a fine based only on that you did it on, the 4th day. Sorry, you were 1 day late. We're going to, and if you got fined on a lot of other things, then we could be talking about, maybe over $2,000 fine just for missing it for 1 day. So, I refer to it because it's easy to remember as the Monday-Thursday rule, because if you think of 3 business days, you need to realize that the Monday doesn't really count. So Tuesday, Wednesday, Thursday are the days that count. So that's why I think the Monday, Thursday is a good test, or something you can easily remember. The first day of employment is on a Monday. We have to have Section 2 of the I-9 finished by Thursday. You have to have Section 1 finished by that Monday. So at least for Section 1, the first day counts. For Section 2, the first day doesn't count. A little odd, but that's the way they've done it. The employee, in presenting documentation, they can present a receipt showing that they're seeking, say, a replacement for their Social Security card, or they've filed an I-90 or an I-765 seeking a new green card or EAD because they lost the one that they had. Now, I think I went too far. Hold on. Okay, so when they do present a receipt, it gives them a 90 days to come back with the actual document. So, and unfortunately, I would say a majority of the employers that I've represented don't ever bother to put it on their tickler list, or whatever you want to call it, to go back after 90 days and see that they have their actual document. It's like, well, out of sight, out of mind. Yep, they gave us a receipt. It's great. We don't want to ever bother to go back but that receipt's only supposed to be good for 90 days. So it would legally, you do need to go back and get that actual document. If you don't, and then you get audited, then you could get dinged by ICE on that. Now, recently, ICE and maybe the USCIS has said, listen, if you get a receipt for, say, a Social Security card, and later on, for whatever reason, you want to give your U.S. passport, then you can do that, and then you would just fill out list A and scratch out list B and C, and put in the notations. Well, scratch out, cross out, not scratch out, and then initial and date, and in the additional information, say, you know, in lieu of that document that we got the receipt from, the employee on such and such a date gave us his U.S. passport, which is both is an identity and an employment authorization document. So list A. So remember that I don't really think too many employers are being sticklers and go, oh, nope, you gave us a receipt for this, we need that document. But apparently there was an issue, and enough of an issue that they issued some type of guidance on that. So you fill in the information, whether it's in list A or list B and C. Incredibly important that you record all of the information. Employers that I've represented, they don't do a very good job of recording the Social Security card. They often don't. If they just write SSC, which really is acceptable, but then they don't write who issued it. And you could put just a whole bunch of stuff of who issued it. It could be the Social Security Administration, SSA. It could be the Department of Health, Education, and Welfare. It could be other departments. They'll accept just about anything. You could put U.S. government; they would accept it. They don't accept the fact that it's blank. So if you don't put it there, and you don't keep a copy of the document, then if you get audited, they're going to find that to be a violation. Even though, do we really care, what the exact agency was that issued that Social Security card? Really, we don't. But ICE does for the purposes of an audit, and they will ding you. Ding meaning equaling a penalty or fine for failure to put that information there. Expiration date is another one that gets left off. Obviously, you don't have an expiration date on a Social Security card, but you do have one on a driver's license, on a passport, on a green card, on a EAD. And people just don't. They leave that line blank. Why? I don't know, but it just happens. They also leave the line blank often, that who issued the driver's license. I mean, if you're in the state of Tennessee, you could just write state of Tennessee. It'll be fine. People tend to just leave it blank for some unknown reason. So that can get you in trouble. So you can't. After you get this information, then you're going to fill out the certification. Some people think that if you've got the documents, but you didn't record it in the actual form, but you have the documents, then hey, everything's okay. Unfortunately, that's not correct. Even if you have the documents attached to the I-9, either for list A or for list B and C, you do need to record it on the actual I-9, because that's, of course, what you're signing and certifying to. Now, if you at least partially fill it out, let's say you leave out the expiration date, you leave off the agency that issued the driver's license, the agency that issued the Social Security card. If you attach those documents to the I-9, that will be what's called a technical violation. If you're going to have a violation, you want it to be technical, not substantive. Technical means you get a chance to correct it during the audit, and you will, if you correct it, you won't be fined. So that's important. A lot of people have the misnomer that you can, keeping the documentation will only cause problems. Oh my God, the ICE will see what document we took. Well, as long as you're not taking driver's licenses that were, issued by, I'm over near Dollywood, say a driver's license issued by Dollywood, or on the other side of the state issued by Graceland or something like that. As long as you're not doing something idiotic like that, the fact that they can see the document that you accepted, the driver's license or the green card, normally that's not going to matter. I mean, I guess if you have a picture taped on the green card, that could be a problem. But most of the time, you are going to be a lot better off having the documentation because you can have a technical violation and not a substantive by keeping the documentation. So, um, you know, you may have been told otherwise. I think 10, 15, 20 years ago, people were attorneys, quite frankly, were often saying, "Don't keep the documentation." So that would be contrary to my advice on that, and that for the exact reason that it will get you into a technical violation, not a substantive. Secondly, if you do keep the documentation and you decide to have an internal I-9 audit by the attorneys like myself, then the attorney can look at the documentation and let you know. Some companies want to know. We really don't want to have anybody that is not authorized to work. Even if we think we're not going to get fined, we just don't want it. And the attorney, uh, if he knows his documents or her documents and can review them, will know, hey, this is a fraudulent document. You shouldn't have accepted it. Get back with that employee and see if they have anything else. If they don't, then you're going to have to terminate their services. Section 3 is for re-verifications and rehires. We already talked a little bit about rehire. Re-verification is say an EAD or a visa that is only good for 24 months or less. Then you need to re-verify that before they get and get the new EAD before the original EAD expires. Again, we do have some of those extensions that are allowed, but it's best to try to get that information recorded onto the Section 3 of the I-9, and you're allowed to give a heads up to the employee. Hey, your green card, your EAD is going to expire in 6 months. You need to make arrangements to have it renewed. Used to be you tell everybody 3 months. Well, 3 months ain't going to do it anymore. It takes them longer than 3 months. It may take them longer than 6 months to get the EAD renewed. So at least 6 months you should give them. So if you're going to put a tickler on your calendar, make sure that you have that information there. Few items not to re-verify: passports, green cards or permanent resident cards, driver's licenses. I once had a client who they parked cars and they also did some chauffeuring. And so obviously having a current driver's license was really important. And so they would go through the person's I-9 every time they got a new driver's license and make sure that new information was there. Well, yes, it was important for them to have a driver's license for insurance purposes. It wasn't important for the purposes of immigration compliance. And it took me a while to figure out, why is this company doing this? And it took a while for the ICE auditor to figure out, why in the hell is this employer doing this? So now, one of the reasons, and some people are like, well, what do you mean? I have to re-verify the green card. But you don't, because even if it's expired, you don't lose your green card status because it's expired. Now, you still have green card status, even if it's expired. The same way, if your passport expires, did you lose your U.S. citizenship? No, you just have an expired passport. So now, if someone comes to you and gives you an expired green card, and they're for a new employee, then you cannot accept that unless it meets one of the exceptions that we talked about earlier on the removal conditions. So anyway, you can get yourself into trouble re-verifying documents that you don't legally need to re-verify. You could bring another agency into play, the Department of Justice. You really don't want, ICE and Department of Homeland Security is enough government agencies to worry about. You don't want to bring in the Department of Justice for that. So, I recommend, and I would think pretty much every immigration compliance attorney would recommend that you do an internal I-9 audit at during the course of at some point, and depending on how good or bad or how often you hire folks, depending on how many internal I-9 audits should you do. If I had my druthers, I would have all my clients do one yearly. I don't get my druthers, so I'm not sure I've ever had a client do them every year. Um, so I'd be happy if they do them every 2 years, especially if they don't do a lot of hiring and they're not a huge employer. Let's say they have 100 employees and their turnover is, I don't know, 10 employees a year. Then they probably don't need to do one every year, but every 2 years, because at that point they've already had 20 employees turn over 20% of their workforce. So the more you hire, now restaurants, quite frankly, a restaurant or anything in the hospitality business, you probably should do your audit every year because your turnover rate is so enormous, probably over 100%, that you're always going to have a lot of new I-9s, and therefore your counsel has an opportunity to look at those I-9s and you get a chance to correct everything. Because if you come in and do an internal I-9 audit that the counsel assists with, and then but you have incredible turnover, and 3 years later, ICE comes in for their audit, and you think, well, we had an internal I-9 audit 3 years ago, so our attorney told us everything that was wrong. We corrected it, so we're great. We'll be great for this one. Except that in those 3 years, you may have hired, the entire new workforce, if not twice, and so that internal I-9 audit is probably not going to help too much because all those people are gone, and you have a whole new crew that has never had the internal I-9 audit. So would be good to do such. You can do it on your own. I wouldn't recommend it, and just you really want to have the supervision of an immigration compliance counsel, sometimes referred to as a worksite enforcement counsel. That is normally not going to be your normal run-of-the-mill immigration counsel that you use for getting H-1Bs and Ls and TN visas, whatnot. Most immigration attorneys, when they hear about immigration compliance and I-9, they leave the room. They run the other way. They do not want to have anything to do with it. And I guess I'm just one of the unusual ones that actually enjoys it. So I'm sure there's some defect along the way of mine on why I enjoy it. But anyway, you do want to have guidance, and hopefully you have guidance from someone who really knows what they're doing. People say, well, I can do it myself. Well, if you're in HR and you were the one filling out the actual I-9 for Section 2, what are the chances that you find your own errors? I would say fairly low. I mean, I write articles all the time, and I always want somebody to proof it. Why? Because I won't find my own error. And same way for the I-9. So there are. You may also not understand how to correct the errors, and so you do it incorrectly, and you end up causing problems. There was one employer, I don't know, probably about maybe 5 years ago, 10 years ago. They said, man, we need to get all new I-9s for our employees because a new edition has come out. And so they did. They went and got all new I-9s. And they didn't really need to do that just because a new edition comes out, but they thought they did. But what was even worse is they threw out all the old I-9s, and then they got audited by ICE. And when ICE says, well, great, these were all filled out in 2018, but this person was hired. All these people were hired in 2014. Where's that I-9? Oh yeah, we threw that out a few years ago. It's like, whoops, you're going to be in trouble. The easy rule on the correcting it is Section 1 errors are corrected by the employee, Section 2 errors and Section 3 errors are corrected by the employer. Why? Because that's who fills it out. Section 1 is filled out by the employee, Section 2 and 3 are filled out by the employer. Now, becomes an issue for changes in Section 2. Say you want to make those corrections, and it was HR rep Mark that was there and did did the certification and the lists in Section 2, but HR Mark is long gone, and it's now HR Rep Mary. So do you fill out? Do you just make the correction right there, or do you fill out a whole new Section 2? And quite frankly, it's going to depend on whether it's some kind of a minor error, an expiration date where you can just go back and you can look at the document that's attached to the I-9 and you can just write in the expiration date, initial and date. Same for issuing authority. Or is it just a massive changes in Section 2? The bigger it is, the more likely you want to do a new Section 2, staple it or attach it to the existing I-9, and always when you're doing these things, initial and date any changes or corrections that you're making. And it's best to do that in a different color pen. There's no I've never seen ICE say, "Whoops, you used a blue pen. You should have used a red pen," and issued you any type of penalty. A little more on correcting I-9 errors. In every internal I-9 audit that I've ever been involved in, there's always at least one I-9 they can't find. Sam Jones was hired 8 years ago, still here, never left, can't find his I-9, don't know where it is. We're certain we filled one out. That's part of our practice, but we don't know where the hell it is. So what do? Get Sam Jones into the office, have him fill out Section 1, and then you fill out Section 2 and based upon the documentation that he gives you. And try to do that, as soon as possible. We've already talked about, depending on if it's a major error or multiple errors, you want to, it says use a new I-9 form. Usually you just use the section that you're correcting. Though you can do an all new I-9 form, but then that means you got to bring the employee back in to fill out a new Section 1. Talked about the minor area there, and you should put a note concerning why the changes were made. It could be, we did an internal I-9 audit. I would not suggest a yellow sticky. Over time, yellow stickies have a way of coming off the I-9, and so you might just attach a memo. It could be, quite frankly, the same memo that you could use for all 50 of them that you're correcting. Found errors in the internal I-9 audit, are correcting them as best we can. And you see this is in bold because I want to emphasize it. Please don't backdate your I-9s. Don't have realize that the employer never dated their signature, or the employee, and you go back and you do it. So often, or it could be you're putting in new you're realizing you didn't get the documentation for Section 2, and so you get the driver's license and you get the Social Security card. There's a lot more options than that, but I'll just use those examples. And then the employer representative fills out the certification and dates it, and he dates it for December 6, 2018. But if you look up top on the driver's license, the driver's license was issued in February of 2019. Well, how did this guy record this, documentation when it hadn't even been issued yet? So that unfortunately happens. I've even had clients that in an internal I-9 audit, did that and thought they had pulled one over on me, and I thought it was kind of stupid because you hired me to help you out, and then you decide you want to try to create as much false information as possible. Didn't end up being the greatest client known to mankind. What if you're presented with a false ID? There's various options. If you get a false ID and then they give you an actual document that's acceptable, you can continue to employ that person. That person may have a different name, and you want to go fill out a new I-9 in the correct name. You want to attach the old I-9. You want to make a notation, hey, John Smith and Sam Jones are the same person, something along those lines. Now, it could be that you have an honesty policy. And if you do, and it's a policy that's been consistently applied, that, if you have some type of material lie to us, then we're going to discharge you, and you're not going to be entitled to be rehired. I just had one the other day. The lady goes, "Yep, we certainly have a policy. If you lie to us, then you're going to be discharged, and you're not eligible for rehire for a year." And they had an employee they liked. The guy just came to him and said, "Hey, just want to let you know, I gave you a fake green card. I just applied for asylum, and I got a work permit. So I want to tell you who I really am and give you the real document." And unfortunately, the company had this policy, and I told him, "Well, you always want to apply your policies on a consistent basis. You don't want disparate treatment to come back to haunt you in another manner." And so they had to make the decision to discharge that employee, even though they really didn't want to. I know we're coming close on time, so I'll try to wrap up. And I don't think I'm going to get to questions. I apologize for that. But we will look over. I will get a list of any questions that were asked, and I will respond hopefully very quickly, so that you will get the answers. And I may be speaking out of turn, but I think there's a way we can give that information out to everybody as opposed to just answering that one person. But I will let someone else figure that one out. But at least that person will get an answer to their question, and maybe the entire audience will.
We can send that to the group who attended today. Absolutely approved.
Okay, fantastic. So access to I-9s, unfortunately, I see a lot of situations where employers are very, very lax on who gets access. These are important documents. Yeah, it's not money, but there's a lot of data in there that, if somebody gets a hold of your social security number, your A number, various things can be a problem. So keep it in a locked cabinet. Keep it in a locked, if you don't have a locked cabinet, but you have a locked room, keep it locked in that room. And even have, and it should not be kept in their personnel file. It's not against the law to be kept in their personnel file, but it is a best practice, in my opinion, too. And I think all immigration attorneys to not keep the I-9 in their personnel file. There's good reasons for it, but it takes longer today to explain that. I will just note that I think it's a great thing to have an immigration compliance policy. I will tell you that I'm not sure I've ever had a client that's hired me that's ever had one, and that's more than just having a paragraph in your employee handbook that says, "Hey, everybody's got to be legal for us to hire you and retain you." In the next two slides, it gives that information out of what kind of information is in there. I think it's great. I unfortunately don't have time to give you a story on why it's so great, but you'll just have to take my word for it. But I think it's a great thing for companies to have. And we'll barely touch on E-Verify. If nobody's used it, it's an internet-based system. Several different government agencies are there to verify employment eligibility of new hires, not of other folks. E-Verify is voluntary on a federal basis, but it can be required under state law, or if you're an applicable federal contractor. Currently, there are 8 states that require E-Verify for all employers, or at least all employers that meet their jurisdiction. Tennessee here used to be 50 employees. You have to do E-Verify. As of January 1, it's 35. North Carolina is 25. Georgia, it's 10. I think Alabama, Mississippi, it's 1. Anybody. Arizona, 1. You have to post some notices. There's 2 notices. One is basically we E-Verify. The other one is we don't discriminate. That's says a little more than that, but that's how I would describe it. And lastly, should you use E-Verify? I went back looking over some old PowerPoints in putting these together, And I found that about 10 years ago that I was recommending people to use E-Verify. I really can't make that recommendation anymore. Obviously, if you legally have to, then I'm not telling you to break the law and don't do it. If you're in one of those states, you're a federal contractor, do it. But there are some real downsides to it. It's this monitoring compliance section of the USCIS. They mine data from the E-Verify, and if they don't like the way that data looks, there's too many green cards for permanent residents. Why weren't there a driver's license and a social security card instead of the green card? They will send you a non-compliance letter, and they could make a referral to the Department of Justice, who will then investigate you for a discrimination via the Department of Justice. Often it's total BS. Green card holders are supposed to carry their green card, so that would be the reason that most of them, they give you the green card, not a driver's license and a social security card. I don't know too many employers that like Big Brother, and I think of E-Verify as Big Brother. It has oversight over your company. So there are some advantages. I just think overall there are more disadvantages. It certainly creates more work for the HR department. They will, the government will tell you it's free, and that is technically correct. They don't charge for it, but if it takes a lot of time for your HR department to do it, then that's taking away from other duties. So you would have to determine there, what the cost is for you. So my bio is on this next page. If you're interested in what I'm talking about, you don't have a question today, or maybe you have a question that you don't want other people to know about. I've had a few of those. They come up to me afterwards. Hey, I couldn't tell anybody in front of everybody that we should be doing E-Verify because we have in Tennessee, but we're not. What do I do? That's fine. Email me at that address, and we'll try to set something up for. Maybe you need an internal I-9 audit, or maybe you've just tomorrow you are one of the unlucky ones, and you get a notice of inspection from ICE, or you're really unlucky and your notice of inspection turns into a $500,000 potential penalty from ICE. Give me a call. I've been fighting ICE now for at least 15 years on these audits. So I love to do it. Love to help you out. So I'm sorry. I've run out of time, and I know we do have some questions, and I apologize for not being able to get to them. But I know your time is precious, and I think I'm already 3 minutes over. So thank you very much. Hope you learned something today.
Bruce, what a great discussion. We received nearly 70 questions submitted to our Q&A box. I think there is plenty of material for us to follow up with the listeners and attendees from today. So we really appreciate your time presenting on this topic. Again, anyone who may be interested in a demonstration of ComplianceHR, feel free to email us at demo@compliancehr.com, or you can submit the form on our website. But we hope that everyone has a wonderful day, and we appreciate you spending some of your time with us. Happy holidays.
Happy holidays.